Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In the professional ethics class for the seniors, I might have told that advocate need not be the mouthpiece of the client. No doubt you can seek instructions from the client and you can expose them in the court, but you should not become the mouthpiece. That means whatever he says, you should not tell before the court, because something may be legal, something may be not relished by the court, something may be not relevant to the case, because of course as a petitioner, as a plaintiff, he has got so much bundle of case, a bundle of things to prove in his case. But what are the material things? What are the requisite things? What are allowed as per law? These things you have to know. So that's why in the professional ethics class, I told you that the advocate should not become the mouthpiece. He has to use his common sense, he has to use his potentiality, and then only inform the court the relevant points. Right? So this is what is stated by the Honorable Supreme Court. In the case, Justice Anirudh Bose and Madam Bela M. Trivedi. In the case of Saumya Chaurasia, she is the PA to Chief Minister of that state. I will tell you later. Saumya Chaurasia versus Director of Enforcement, SLP number 8847 by 2023, decided by Honorable Justice Anirudh Bose and Bela M. Trivedi. Right? So, this Saumya Chaurasia, she was the former Deputy Secretary to ex-CM of Chhattisgarh, Bhupesh Baghel. Yeah. Of course, she was involved in a case of Prevention of Money Laundering Act, and the charge sheet was also filed against her. Right? So, Chaurasia appealed against a decision of the Chhattisgarh High Court denying her bail in the Prevention of Money Laundering Act 2002. Right. Here, the important point is, no doubt, the High Court denied, but the pleadings, before that I wanted, the advocates definitely, they will draft the pleadings as per the version of the plaintiff only, or the written statement will be written as per the version of the defendant only. But before writing the same, the advocate should go through the record. Please remember, though it is true that the advocates would settle the arguments or pleadings and argue in the courts on the instructions given by their clients, however, their duty is to diligently verify the facts using their legal acumen, legal knowledge for which they are engaged, and they cannot obviate the same and tell whatever the petitioner says without verifying the facts. Here, before Madhya Pradesh High Court, same thing happened. Right? The Madhya Pradesh High Court, actually, they came to know when she filed the bail petition, it has denied, basing on the fact that the charge sheet has filed against her. No doubt, in the charge sheet, certain allegations against the other accused under the Prevention of Money Laundering Act, they were waived away. So that means some of them, the charges against some of them were not under the Prevention of Money Laundering Act, but in some other sections they have been added. As regards her, the Prevention of Money Laundering sections are there. Of course, she says that she is not responsible. The allegation should go away. That's a different thing. Right. Now, when she approached the High Court, then the High Court did not deny bail to her. Then when the Supreme Court asked, did you inform the same to the High Court? Did you inform the same to the High Court that the allegations of PMLA will not apply to you? The lawyer said yes. But when the record is verified, they did not inform the High Court, because before the charge sheet is taken on file or before the material facts have come to their notice, before itself the High Court has reserved the judgment. When once the High Court reserves the judgment, the matter is seized. Definitely, they would not have told anything more than that. But before the Supreme Court, they stated that they have informed the High Court, which is not correct. As a result, the Honorable Supreme Court of India imposed a cost of 1 lakh rupees to be paid to the Supreme Court Bar Association. So, things should not go like that. You should be fair now. What would have happened is simply the plaintiff or the client would have told the advocate that the Honorable High Court has also seen, but they did not take any action. We have told the same before the High Court. But they did not tell the same before the High Court. So it should not be accepted. So please remember that you can appear before the court, you can apprise the facts, you can contact your client, but you have to verify. Without verifying the facts, you should not become the mouthpiece of the client. Alright? So when this topic comes in the ethics, we will discuss in detail. So for the present, I am staying back. Have a happy Sunday. Thank you very much.